discuss about some of the important provisions with regard to granting bail under the Prevention of Money Laundering Act. So why this is news? Because the Supreme Court has upheld certain provisions in the Prevention of Money Laundering Act with regard to granting bail. And it has also used terms such as terrorism when defining money laundering. So let us see why. This section 45 clause 1 in the Prevention of Money Laundering Act is with regard to granting bail to the accused. So what this provision says is the public prosecutor will be given the first chance to oppose this bail application. So when an accused is applying for bail, then the public prosecutor will be given a chance to oppose this. Then if the court believes that the accused is innocent of the charges, only then the bail will be granted. So this is a double burden on the accused. So let us see if there are any similar provisions in other acts. The section 43D clause 5 of the UAPA, that is the Unlawful Activities Prevention Act, has similar provisions, and Narcotics, Drugs and Psychotropic Substances Act also has such provisions, and the Terrorist and Disruptive Activities Act also had such provisions. So you can all see the nature of offences, and I think you can analyze why the Supreme Court has used the term terrorism when talking about money laundering. What is the role of the judiciary? So, in the Kartar Singh versus the State of Punjab Act, the Supreme Court had upheld the provisions in the Tata. So, the section 20 clause 8, which had similar provisions such as 45 clause 1 in granting bail. But the Supreme Court in the year 2018, in Nikesh Tarachand Shah versus Union of India case, had held that the section 45 clause 1 to be unconstitutional. So let us see what is the recent judgment. Okay, as the Supreme Court reversed its stand. So let us see in the further slide. So as I told you earlier, after the Nikesh Shah case, the Parliament amended the Act. So this 45 clause 1 was amended, and the 45 clause 1, that is, which has the twin conditions for granting bail, was made applicable to all the offences under the PMLA. It means the section 45 was not removed. So the Supreme Court now has upheld again the section 45 clause 1 of the PMLA, and has made harsh statements such as comparing money laundering to terrorism. So it is substantiating its judgment, saying that the provisions of the 20 clause 8 under the TADA and this 45 clause 1 are almost similar, because money laundering can lead a threat to the sovereignty of the nation. So Supreme Court says money laundering is also an equal offence to that of terrorism. That is why it has upheld the section 45 clause 1 of the PMLA. I hope this video will be helpful to you. Thank you.